we give notice to that the meeting will be recorded and stuff. Lieutenant Kenneth's getting the recording started. Thank you for everybody that's here in person, but also virtually as well. Thank you. And again, thank you all for taking time out of your summer schedule to be with us. That means a lot. And we really appreciate it. We've obviously got quite a bit of work done and there's more work to do, and very appreciate everybody's efforts. Apologies for my tardiness last time. I had to join virtually, but I'm able to be here now. We're going to do a quick roll call. We're going to pull up a list of members here in just a second so we make sure we do a roll call. All right. Who's representing the Criminal Justice Committee of the House? Thank you, sir. Present. Good deal. Chair of the Finance and Ways Committee.
Watson right there.
All right. Thank you, Senator Watson. Appreciate it, sir. Chair of the Senate Judiciary Committee. Thank you, Senator, being with us. I'll sit in as the Commissioner Designee, the State Treasurer's Office, who's represented. Thank you so much. And the member representing the County Service Association.
Yeah.
Thank you, sir. Join us again. Appreciate it. And the General Sessions.
He's supposed to be here.
She's supposed to be here. Okay.
So she's supposed to be.
Good deal. All right. And the governor from the member for the governors. Thank you, sir. Thank you.
I had seen.
Yeah,
Yes, she's on time. Yes, Miss Representative Hazelwood's online. Thank you so much. We appreciate everybody joining us that's here. Obviously, we got a few more still signing in virtually, so we'll get that kicked off. Give some folks a minute, time to approve the minutes from last time for a January 26th meeting. Have a motion for the minutes, somebody to approve those.
Well, let's give everyone a little bit of time to see them through.
Awesome.
There you go.
Who got it?
Oh, that's yours. Not there.
Folks that are down in virtually, how's the audio and video this time?
Much better.
Thank you. Thank you.
To approve the minutes.
Good deal. Thank you. Have a second. Second. Thank you. All right. All in favor of approving the minutes? Opposed? Great. Thank you. Great. We're going to go a little, you see topic number 4 on our agenda. We're going to swap up just a few things to help with the flow of the meeting and stuff. We're going to touch, first we're going to hit on the introductory presentations from the vendors and stuff. And first up, we'll do the Tennessee Alcohol Monitoring System. Mr. Leonard.
Thank you very much.
You're up. All right.
I appreciate it. Thank you very much for having us. I'm honored to have the opportunity to talk to everybody here today. The intent of moving here is maybe just to give you a bit of perspective of what a state nearby that is doing for indigent funding. We're Tennessee Alcohol Monitoring Systems. We're a service provider. We are a subsidiary of Ohio Alcohol Monitoring System, who's been operating in the state of Ohio for nearly 20 years. A service provider, just real quick background, is somebody who will take these instruments that you guys have been discussing, alcohol monitoring devices, GPS, and provide a program and services around those so that we can move the person to do that themselves. So what we've been very fortunate in Ohio to have availed ourselves of is an indigent fund, 2 indigent funds actually, called the IDAM and the IDAT funds. In June of 2008, Senate Bill 17 in Ohio created the IDAM or the IDIAM fund, the Indigent Driver Interlock and Alcohol Monitoring Fund, and it expanded the IDAT or Indigent Driver Alcohol Treatment Fund. So we are very fortunate in Ohio to have both of these funds available to us. There were some slides.
Let's pull it up.
And pull the slides up. We're going to share them to the group. Members sign in virtually. You're fixing to see a PowerPoint presentation up here.
And we're actually a little out of order. I'm going to speak for you.
Yeah,
If that's okay.
that's fine.
Yeah, absolutely. However y'all
Real
want to,
quick.
yeah, however y'all want to go.
Okay, thank you.
If you'll share that PowerPoint, we can let them kick off.
You have to share it virtually too.
Yeah, that's what I got to do first. Sorry.
Thank you.
While they're working on this, can I ask you a question about Ohio?
Yes, sir.
How do they define industry in Ohio, and how do they pay for industry in Ohio?
Great question.
Because, we got a definition on a lot of states right here, but Ohio's not one of them.
Yeah, and we were talking because this is what we were talking about last 24 hours with it as well. So
And I'll put it-
I actually, and I can share this with you too, if you'd like me to email it. But indigent is defined as an applicant whose gross income is 187.5%.
So that's similar to a couple other states that
Yeah.
have 187, but it's as low as 110% in some states. We have here, the other question, who compiled this list of industry? Okay, was this the definition of industry for a criminal proceeding or for what, something more similar to what we're looking at?
I'll double check and get back.
Because I know we had that discussion, how there's,
Right.
it could be different when you're looking at a constitutional right versus this. And so I'm kind of curious about if they have different definitions depending on what subject they're addressing. So,
Do you guys know that?
No, I mean, I don't know the other states, you know, obviously in Tennessee, we don't.
Right.
So.
okay, all right, I'm sorry.
Okay, so good morning, everyone. Thank you for inviting myself, Mindy Huddleston with Scram Systems and Brett Leonard here to speak with you today. I have met some of you at past meetings and just wanted to introduce you to what Scram Systems is. So many of you may know the alcohol monitoring ankle bracelet, and I think Brett has one if you've never seen it. So Scram originally, over 20 years ago, actually created and engineered this technology, which never existed prior to the bracelet. It was the first transdermal alcohol monitoring device on the market. And it was created because the inventor of the device had a friend who was killed by a repeat DUI offender. He had been working at an alcohol testing company, which did breath alcohol testing, and said there must be a better way to test people. So over the years, we've expanded our product line for offenders. Alcohol monitoring has always been the thing that we do most and what we're most proud of, but we also do location monitoring. We also have a handheld alcohol monitoring device, and you can see these in later slides. We have tested over 4 billion tests. So the alcohol monitoring ankle bracelet, it tests every 30 minutes, 48 times a day for the presence of consumed alcohol. For those who don't know how transdermal alcohol monitoring works, 1% of all consumed alcohol comes out of your pores unchanged. There is a sensor in here that takes a sample of the insensible perspiration off the individual's ankle. It tests for alcohol, and it's called a transdermal alcohol content rather than either breath or blood alcohol. There is an equivalency of the two. So not only do we know if someone has been drinking, but we have a sense of how much they've been drinking.
Just let us know when to scroll down.
Just say next slide,
Okay,
please,
no
and
problem.
I'll be able to.
No problem, will do. So anyhow, so Scram Systems merged with another company last May. We are 800 employees, and no longer are we just headquartered in Littleton, Colorado, but we have multiple locations throughout the US as well as in the UK and in Australia. So next slide, please. So as I mentioned, there's a few technologies that we provide: our sobriety monitoring with the alcohol monitoring device, a handheld breath testing device for people who may not need the same level of alcohol testing and accountability. But then we also have mobile check-in devices that are app-based for probation supervision and other things, as well as ignition interlock. Go ahead. So you probably already realize the benefits of monitoring people in the community as opposed to keeping them locked up in jail. Obviously, we're going to save money. Incarcerating people is expensive. I don't know what it is on average in Tennessee, but I'm sure it ranges anywhere between $30 a day up to likely $75. Whereas monitoring typically is $10 or less a day. So we're trying to reduce jail costs, but we're also trying to improve lives. We want to improve public safety for people. And often what we know is those people who are DUI offenders, even repeat offenders, we don't like them. We don't like their behavior. We want that to change. But if they are not drinking, they will obey the law. So that's the one thing that we're trying to accomplish with sobriety monitoring. Enhancing public safety, but also keeping them within the community so that they can continue to work and be part of their families. So this just gives you a little bit of background in a very visual way of what we do with the alcohol monitoring ankle bracelet. So what we know is over 99% of people on any given day, and we monitor over 20,000 people daily, they will stay sober on the alcohol monitoring ankle bracelet. And it's very simple. If you know you're going to be caught, you're going to change your behavior. But also what research shows us is those people who are on the bracelet for a minimum of 90 days change their behavior long-term as well. So it's not just while it's on the ankle, but there are long-term recidivism changes as well, which is, you know, what we're all striving for is long-term behavior change. So as you can see, you know, we've monitored nearly 1 million people in the last 20 years with over, I feel like on McDonald's, with over 4.3 billion readings. I wanted to give you, this is just a little snapshot of the electronic monitoring and some of the data that we can provide as a company. And this is specifically for Tennessee. So you can see some of the number of bracelets that are being used, either continuous alcohol monitoring, GPS monitoring, house arrest, and then our remote breath testing. I should also mention that the alcohol monitoring ankle bracelet does have a house arrest function that can be turned on if needed. So if someone is non-compliant, and what we do see is about 10% of people are non-compliant. Those are the people that really have a hard time stopping drinking. And if they're having a hard time, they may need further assessment and treatment because they're not able to stop on their own. But, you know, one of the things that you could do is also then increase or turn on the house arrest function as an additional sanction if needed, or simply turn it off. So I just wanted to give you a little bit of a sense of, you know, some of the data that we see. So I'm going to turn this over to Brent, who, as he mentioned, he's a longtime service provider in Ohio. He is assessing the market here in Tennessee to enter the market and provide services in Tennessee as well.
Yeah, and thank you again.
I'm sorry, this is Patsy Hazelwood. A question before we go on, if you might indulge me. You mentioned the long-term, I think it was 90 days or more, then you see a long-term rehabilitation, I suppose, or lack of alcohol use. What kind of monitoring do you have, or what kind of data do you have to determine, I guess in the prison system we would call it recidivism, but how many of the clients that you work with that are 90 days or longer on your equipment do we rearrest or have problems with down the road?
Okay, so I can provide to you the published results of the studies that have been conducted that show the reduction in recidivism based on 90 or more days of continuous alcohol monitoring, specifically on repeat DUI offenders. As far as the data that we collect, we don't collect all of that criminal justice data necessarily to know who's been rearrested either for a DUI, assault, or any other alcohol-related offense. So we don't, unfortunately, we do not have that data as a company.
All right, thank you very much.
If there's no other questions, then I'll just again reiterate that in Ohio, we've been very fortunate to have 2 funds that are available to our courts and our offenders and defendants when they are found indigent to receive subsidized monitoring. Like I said, in 2008, Senate Bill 17 created the IDM Fund, and just think of IDM M monitoring and IDAT-T treatment fund. Those, if you go to the next slide.
His slides are right after mine. We
Oh.
collapsed it, sorry. We were trying
So
to,
it's not on the same.
it should be it's on the same presentation.
Is it a dedicated
Oh.
fund just for this purpose?
Oh,
It
you're
is.
right with,
There's actually two purposes. So the IDAT fund is treatment oriented. It can, and a portion of it can be used for electronic monitoring. And this is what I really like about the IDAT fund, that the legislators when they created it, essentially gave two keys to unlock that funding for an indigent offender. And that is one to the judge to prescribe it, see the need for it, and then also to a treatment facility to determine that it's clinically necessary and make it part of their treatment program. So in Ohio, we have taken on a very treatment and rehabilitation oriented kind of philosophy when it comes to electronic monitoring, specifically alcohol.
And what's the revenue for this fund? What's the source of the revenue? Is it general fund money? Is it fees?
So it's not general fund money. It's great. Actually, a great question. And that's what this slide here is. It's from license reinstatement fees. You'll notice that number to the left is incredibly high, $475. So it's a very large license reinstatement fee in Ohio. And $37.50 of it goes towards the Indigent Alcohol Treatment Fund. $50 goes towards the Indigent Drivers Interlock and Alcohol Monitoring Fund, whereas the remainder goes to its other.
But again, to get their driver's license reinstate, that's the fee they had to pay.
Yes, sir. Yeah.
What's the fee for getting driver's license reinstate?
$65 for reinstatement.
Wow. So that's a high fee.
There's been a lot that has been attached to that. Yeah.
Can I ask a question about that? Is that just for the reinstatement of DUIs or all reinstatement fees? Because ours can be really high if it's coming from all.
To the best of my knowledge, this is for all license reinstatement fees.
So like if you lose your license for not paying your court costs, you're still going to pay $475 reinstatement fee.
That's my understanding of that.
So so in Tennessee, if your license is revoked, if you want to get it reinstated regardless of the offense, it's $65. But that does not go into, that doesn't account for what you may owe the courts or what you may owe the department for fines that you've accumulated. So it's just a flat to get it reinstated after a revocation or suspension is
And that goes to
$65.
Department of Safety.
That goes to our DL for administration of them.
But can I ask a question? Because I have people all the time tell me the reinstatement fee might be $750 or well, maybe $500. So that's at the Department of Safety, but you only get actually that $65 of that.
So if someone has a lot, it means they have a lot of revocations and they have a lot of things on their license. that have been
Ever revocation.
So it will accumulate, but also there are fines assessed depending on the type of conviction you get as
Right.
well. And so you'll have some people who may owe thousands because
In
they've got like
reinstatement fees.
20, well, it would be reinstatement fees and
Right.
fines and fees total. So there's some reinstatement fees in there, but also they probably have, 10 speeding
But
tickets.
they pay us that part of it, but they pay you all. the
Ours is
rest of that.
completely separate from what is owed to the courts.
So,
So it's two different sets of fines and fees you owe for the courts and then for the department.
okay, so it's not necessarily just 65, but it's 65 per event that they owe.
Yes, but some events, a few years ago, I know Leader Lambert carried the bill. I don't know who carried it in the Senate. They got away of like the accumulation of suspensions for like
Right.
failure to have a license because it was just continually putting people in the red. So it doesn't always play into it and it doesn't always accumulate. So it kind of just depends, but we even know the 65 doesn't cover the department cost at all. That's the breakdown.
And in Ohio, this is our breakdown just for the license reinstatement fees. So again, $37.50 goes to the IDAT fund, $50 goes to the IBM fund. These fees are obviously collected by the Ohio Bureau of Motor Vehicles. And then from there, it takes two different paths. The IDAT fund will follow the Ohio Mental Health and Addiction Services, and that goes to a county board. And then it's distributed to the court of jurisdiction that has the statutory authority over that fund. Whereas the IDAM funds will follow a different path and go through the Department of Public Safety. There are limitations on how this is to be used. It's for sentenced offenders only, for a traffic offense that are found to be indigent. So we don't technically have a pretrial fund for, any indigent funding for any pretrial offenders. That's not to say that this hasn't been used for that, but just legislatively it's not. The next slide. Thank you, sir. The IDM fund, again, can pay for all or part of the cost of the certified IID, or part of the cost of remote alcohol monitoring device, whereas the IDF fund can pay for the cost of alcohol and drug assessment, alcohol and drug addiction treatment program, transportation to and from that treatment program, the cost of medication assisted treatment, and then, and only then, the cost of the alcohol monitoring device if the IDM funds are exhausted. I mean, they've exhausted all of the fund that is just for monitoring and determined to be clinically necessary and used in conjunction with an addiction treatment program. So those are the two keys that I kind of mentioned earlier. Thank you. There's also another source of funding, and that is again just the Obi Fines. So these will be retained by the court, $50, essentially matching that license reinstatement fee for the IDM fund. And then you see again the $37.50 for license reinstatement fees for IDET. We can also assess a $25 OBI fine, $1.50 for every moving traffic violation, and $50 for immobilization. So they can independently build that. The way that we're notified, at the service provider level, the only notification that we will get that somebody is going to be paid for out of these funds, and if you can go to the next one, is that registration form. Sorry, that's up there, but they're essentially just identifying this person as court pay, and we just simply invoice our customers' courts monthly.
Do you contract with state, individual, judicial jurisdictions, and is it a competitive bid process?
We contract with an individual jurisdiction. We operate either by contract, MOU, or sometimes it's not even contract. Doesn't meet that standard.
Most companies though in this.
There are, yeah. Ohio is, I don't know, it's fairly competitive. I wouldn't say that there's other states that have probably more competition, but Ohio EMS is the largest in the state doing this. But there are other. And that's all of those fees and fines. And I apologize, I actually updated the slides. So this is, I found additional information that I wanted to share with you, so I may be able to read it. But historic total since both of these funds have been in existence, the IDAM fund had generated about $19.1 million, $19,190,000, and the expenditures were $19,117,000. So it still has surplus. Whereas the IDAT has collected or generated $17,636,000, and the expenditures were $15,367,000. Just to give you an idea of the magnitude of funds.
Those are lifetime.
That's all the information I have. I just appreciate the opportunity to give you guys another example of what a state, it's not adjacent, but nearby that's getting. We really invested in this type of monitoring and this technology because it is depopulating jails. And again, with the treatment kind of philosophy here, we're seeing at the misdemeanor level of the DUIs, we call them, addressing the underlying issues.
Well, and I had hoped to be able to provide you with what other states are doing at a state level to offset the expenses for indigents and electronic monitoring. Ohio and Tennessee are the only two states that do this at the state level. Most states are, and you will see at the county level, counties all have their own policies and agencies have their own policies on how they handle indigents, and whether or not they pay for it out of their pot of money, or, if they negotiate services, whatever it might be. But, Tennessee is definitely cutting edge on thinking forward this way, because the reality is a lot of states, don't know how to handle the indigent population. Frankly, they want to protect public safety. They want to keep people out of jail, especially those that we're not scared of if they're not drinking. But, it becomes an issue of fairness. And not everybody, if you can afford it, gets that opportunity. So those who are less able to pay end up in jail, and that becomes problematic to say the least. So I really thank you for trying to figure this out and figure it out, systemically and long term.
And if I could just add one other thing, that this is a rather objective process in Ohio. Where the license is reinstated, where that person is originally sentenced is where those funds will get distributed to eventually. It's not necessarily an indication of where the need is for the indigent funding. And so that's just, it's simply not addressed by the way these funds were created. So I know there's urban areas where the license reinstatement fees probably are not plentiful, but there's a lot of people who are still accumulating OBIs, UIs, and the indigent funding, it doesn't keep pace with the population. Just, I figured that was worth noting that that's.
I have a question on slide 13. Can you go back to slide 13, Kevin? Where it indicates court pay, does this person or participant, do they come to your facility or go to a facility indicating that they've been declared indigent and y'all submit the claim that way? How does that process, what does that process look like?
It's actually really easy. The relationships that we have with these courts, they're sending us this referral form directly. So we know that this person is coming our way. This is just our business model. We will contact the client, start to create a monitoring profile, and then reach it. We're highly mobile in Ohio. That's how this has worked out there. So we go to the jail, probation department, person's workplace house. But this is simply, as far as the payment is concerned, that's indicating to us start to build a court.
I'll build the court individually. That's where the offense happened. Y'all build them on an individual basis, county by county. Any other questions, both in person or online? Yes, sir.
Do you know what percentage of people whose license are revoked pay that $475 to get it back?
That's a great question, and I don't have an answer to that, but I will certainly, I'll do some digging and try to find out.
I think everybody, right? Pays the reinstatement.
Well, everybody that gets their license reinstated pays
Yeah, a
it.
lot of
but
people
what percentage
don't
say I don't have?
See, I think you didn't
$500.
understand your question.
I was interpreting your question as of X amount of people that have their license revoked, how many do get it reinstated and pay that fine?
Yeah.
So, yeah, I'll find that.
Anybody online have any questions?
Yeah, this is Senator Watson. Do the vendors offer any kind of discount in their charges to the indigent population?
We do. Historically, Ohio EMS operating in Ohio has been cognizant of the fact that this is a finite amount of money that's distributed each year. So we lower the cost to the courts by about 20%.
What
Do you
is the,
do that on a case by case basis or just in general?
Just in general, that's been a general standard.
this is Senator Watson. In our current arrangement, Elizabeth, do the vendors that work with the state of Tennessee, do they provide a discount to the indigent population?
That may be a question for Treasury. I don't know if it's a discount, but it's, you can just have the fees paid for and reimbursed to the vendor, but Treasury may be able to
It
clarify
is
that.
our understanding that that is a discounted rate. I don't, because we cap how much we'll reimburse at $200 per month.
Yeah.
So our belief is that I don't think it's a formalized discount. They just know that's how much we'll pay. So that's what they charge.
And the most they can charge a month is $125. So the vendors can. So if y'all cap it at 200, that would cover it.
That
Great.
for all types of monitoring
Only ignition
and
interlock.
ignition interlock, okay,
The others would be
200.
200, yeah.
200.
So in Ohio, the reduced rate is $10 a day, or essentially $300 a month. And that covers pretty much all of the operating expenses, the cost of goods sold to take that device, own it, finance it, put it on an ankle, the monitoring fees that are associated with that to the manufacturer.
And
That's important to remember that.
Well, and if I might make a differentiation here, that is when you're utilizing a service provider to do all of the work, the installing the bracelet, doing all the monitoring, everything soup to nuts. Agencies can do it themselves if they own the bracelets, and they can choose to do the installs, removals, daily monitoring and reporting, and then that would be less expensive. So it just depends.
so it's
if they
200
have the
either, whether
personnel.
it's, so we have some counties that do it themselves. We have some that use just private vendors that handle all that. Across the board, it's $200 per month.
I would guess though that, the cost monthly for the non-interlock devices are probably more than the
They
other. Yeah.
Significantly more. Yeah, I mean, I don't I can't speak to every interlock vendor, but I would say typically it's in that 100, you said it's capped here at 125.
Per month.
Yeah, and the cost of operating electronic monitoring equipment is significantly higher.
Well, especially when you're taking 48 readings a day, not 2 or 3. So it's just different equipment.
300, that's just for the transdermal monitoring, or is that
That is, yeah.
300 a month, just transdermal? What fees do they pay out? What's the max y'all pay out on an interlock device a month?
Unfortunately, I don't have any perspective on that. We don't do any
Transdermal.
Yeah, our company does do interlock, but I just don't even have that information, but I could find it.
Elizabeth, this is Senator Watson again, and I'm sorry being online, it makes it a little bit more difficult. Can you tell me again what the cost per month is for Tennessee for both the interlock systems and for other systems?
For interlock per month, we have it capped. They cannot charge more than 125. So it's anything up to 125. I'm not sure about the other though.
So this is Erica Nail with Treasury. For non-interlock devices, we have a cap of $200 per month for all non-interlock devices.
And in Ohio, is there any requirement that even if the person is indigent, they pay at least some portion?
Great question. No, and maybe I could answer that by he had asked about the standard of indigence. That definition that I gave you is linked to the IDAT fund for the sake of applying those funds for treatment. When it comes to the monitoring components, it just simply, the ORC simply just reads that the court finds that they're unable to pay for all or part of that. So it does leave the door open for a prorated amount. And we do find and do wholly believe that every participant in these programs that has some skin in the game, whether it's 50 cents a day, $1, or $8 a day, are more successful. And it's just an anecdote about that is, you know, when we were a very small company and perhaps I was filing violation reports, we had 2 sets of files. One was all the 100% court paid people and one was 100% client paid people. And just my recollection is that I was filing violations in the 100% court paid people more frequently than that. So ultimately, we believe in that. We can do that. I think any vendor that serves the state should be able to prorate that.
Well, and that's one of the things that Judge Staten mentioned last time we met, and I think whatever recommendation that we come up with to give the legislature, it needs to have that component in it. What Hamilton County is doing practice right now, I think it would be a great practice to have across the state and us to tell them to do that instead of Hamilton County doing it on their own. Let's tell them to do it.
Well, if I may add to that, you know, Brent has that anecdotal data, but there is research that shows individuals who pay what they can afford and not more have better outcomes than those that don't pay anything. So, and again, if you can only afford $1 a day, you do have just more buy-in to the solution.
That's a general principle.
Just want to say there's research.
And on that 475 license reinstatement fee, is that absolute or is there any provisions for payment plans or waiving some or all of the fee for persons that are indigent, or is it 475? No ifs, ands, or buts. You don't drive until you pay.
My general understanding that, you know, that is not something that can be negotiated at the court level with waive fines and fees. So this is a BMV fee, and I don't believe that there's any.
And for our purposes, we can't waive the fees either for anything that you owe the department. However, we do offer payment plans for it.
John, I will get back to you on whether or not the payment plan.
Any other questions? Thank you all for your time so much. Really appreciate you coming in and visiting us. All right, we're gonna go back to the top bullet point under number 4 there, the definition of entity and proposed languages for that. All right. Thank you.
Senator, I believe to answer your question is that the definition from those states that we found was just a general application. It wasn't unique to programs similar to this. That said, we were coming up on about a month and a half left before our recommendations are due to the General Assembly, so it seems like it may be prudent of us to spend our time focusing on this definition specific to and the constraints of this program and continue the larger indigence conversation, outside of just in this task force. Talked to several folks and there's just a lot of programs, a lot of stakeholders that need to be engaged. So we kind of think that it may make sense to focus our work on the EMIF specifically.
All right. Let's open up for conversation about the definition and we'll go from there, okay? Proposed language and so forth. I think officially, I think
It's 150%. Was it forgive me, it's an and here, I haven't phone by memory, was it an and or an or? Was it,
It's an or.
Okay, so it was, the different, government program, Medicaid.
Yeah.
Or it's in here.
Yeah.
Like for everybody, it's in the agendas and one floor, we have a materials.
This is Senator Watson. To the members of the judiciary, how difficult is this information to ascertain?
So it would be about impossible for us to ascertain, like, are they like, are we going to require them coming in with all their paperwork? Because we do that in no other type of indigency model. I just don't know. The way the statute's written right now, it only asks the two questions that is included in our form. And I think maybe the way that might be easier for the judiciary is if we put more questions within the statute to be asked by the judge.
So what are the two questions now?
There, it's 185% of the poverty level. How much do you make, basically? And how many people live in your home?
Okay, and when you ask somebody how much they make, do they have to show you documentation?
No.
Goodness, I mean, how does this work then? And I know to verify it is gonna slow down the system, but not to verify it, then I can tell you whatever I want to tell you.
Right, but they don't know the amounts, so they're always, it's very interesting in there. They don't know where the cutoffs are. And so I mean, even though we have a list for ourselves on our paper, they don't know where the cutoffs are with the amount of people in the house, and it actually has that within it's on our form. So, obviously I can't prove how many people live in their house unless I go up to their house. Many people that ask for that fund are on disability. They could bring their amount very easily. A lot of people work sporadically at.
Well, even the ones on disability, do they have any documentation to show you they're on disability?
Not usually, no. I had yesterday, so I made pictures of them, the people, like this guy. I mean, we're not talking like people with a lot of money. They made $13,000 and 4 people lived in their house. So I did require them to pay $10, but imagine you're dividing 13,000, how much he's actually bringing home. This guy gets $840 a month in disability payments. And so is he going to be able to take $125 a month? But if you don't give him the ability to drive, he's not going to even be able to, maybe some people can get to a second job to work up to like 20 hours a week. So most of the people asking for this, at least in my experience in Hamilton County, aren't people that are making, $30, $40, $50,000 a month. They're people that are, you know. It seems like most of
I
it,
can't think of any other, and I would call this a benefit. We're bringing somebody in to say we're gonna pay. I can't think of any other benefit that we give somebody without asking for some kind of proof.
and we don't do that even in a lawyer either. They put down, you know, I ask them, how much rent do you pay? How much do you have a car payment? How much are your credit cards? I mean, they could lie or not. I mean, but if I spent, you know, an hour a day, I have, you know, hundreds on my docket every day. And so you're right. I mean, you are right.
Yeah.
You know, if basically the easiest way is if there was like an administrative law judge or somebody like that hears our appeals on when we seize money at the Department of Safety that would sit there, they would have maybe time to take in all the documentation on electronic,
And
on the internet.
I'm just thinking aloud here. So
Right.
is there no way that we could include this information and what they have to have as part of their, you know, their case when they come before a judge, that we require, you know, if you're going to be asking for indigency, you've got to bring stuff with you at first. I mean, could that not be done?
You can require it, you know, in the statute.
Yeah.
Now, whether they bring it or are able to provide it, that's another question. I mean, it just. is
And
the
then,
reality.
but then it at some point becomes counterproductive because we want people to have interlocks because we know it's better for the public safety. And so,
Do they not have, everybody who's in your corporate, it's either got a lawyer or a PD, don't they?
These,
not on DUIs,
Okay.
a lot of people, I mean, if they're charged with something more serious, most of them do. A lot of people I see come in with DUIs and they're like, I'm guilty. I just want to know what the minimum is. And because if they hire a lawyer, most of them are going to cost them $2,500 to $10,000. I mean, maybe. And so even though they're not indigent, imagine you're making $30,000 a year and you're trying to hire and come up with $2,500. But there are people who do have attorneys, and obviously if they can afford to pay somebody $5,000 to $10,000 for an attorney, and they made a bond, and you know we can look and see. But and that's one of the things I think we've talked about is maybe adding additional questions without not overburdening, but at least include some questions if you wanted us to go into more. But the statute was written in a way that that's all we would ask.
Excuse me, this is Patsy. What other questions would you recommend, Judge?
Well, if you wanted us to go more into the indigency, you might ask if anyone else in the household has an income. Because what we're just asking on our form is what is your income? And say you're a man in the household and you're a stay-at-home father and you don't work, your income would be zero, but your wife may be a medical doctor. And so maybe the household income of everybody in the home. I think it does say, does it say household income? I thought it said
any other
how much.
I mean, there's an option where you can list it, but it doesn't say.
The statute says the person is receiving an annual.
Yes. And so maybe if we include household income, that might be something that would help the courts look at it more fully.
Any other suggestions?
Could I give you an example of what the
Yeah.
Ohio RSC is, if I may?
Yes.
We talked about the 187.5% of the federally established poverty level. But it does go on then to say that the applicant currently, this is presumptive eligibility, and the applicant is presumed indigent and doesn't entitled to the appointment of counsel, this is again for application, at the expense of the state under the following circumstances. The applicant currently receives poverty-based public assistance such as federal supplemental income, Ohio Works First, temporary assistance, So they're looking for you to have been receiving some kind of dollars. It does consider, to your point of asking additional questions, wages and earnings from employment, other liquid financial assets, the number and ages of persons the applicant has legal duty support, basic living expenses, court imposed obligations, including allowance to fees, fines, costs. Let's dig a little bit.
You asked about public assistance.
No, we do when we're, for an attorney, we do, but not in this. We only ask the 2 questions that are included in the statute at this time.
Sure, let me ask you one question. It's probably 90% of these cases being heard in general session, and maybe a small percentage would be that somebody would have a lawyer, would be heard in circuit.
Somehow we booked that, but.
The vast majority of these sections, okay.
So the public assistance piece is what we talked about a little bit in prior task force meetings, is what we tried to do in 2019, which is once the judge signed off on it, it would go to DHS, for example, and they would confirm whether the person was receiving like SNAP or TANF or that sort of thing.
This is Senator Watson again.
Yes.
And this is just food for people to think about. What responsibilities are tasked to the vendor? For example, could the vendor be responsible for ascertaining the information before applying the device?
Based on the department's work with the vendors, they obviously do amazing work. We've all talked with them, but we brought a bill this year so that we could actually take action against vendors who maybe are doing things inappropriately. Again, that's not all of them, but you know, for some of the vendors, and well, for all of them, it is they make money off of these devices. And so if we were to give them the oversight of declaring indigency without some type of like oversight of them, which we have had to vamp up what we do for oversight because we have too many situations where somebody is wrongfully extended, their device is not removed when it should be. I'm not sure if that would be a good idea just based on our experience with some of these companies.
And I will add to that, and I can appreciate that, and I'm aware of the new statute about the vendors. In other states, we do have service providers, and generally they are statewide providers, and typically the largest provider in the state that do conduct the determination of whether or not an individual can pay and how much they are capable of paying or not paying. So I know Ohio EMS has not been in that situation, but we do have other large vendors that do that. And then, you know, they either, if there's any indigent, they negotiate with the state or the county, however they need to, in order to provide the services appropriately. And I would say, yes, if you wanted a service provider, and I don't want to speak on your behalf, Brent, but if you wanted a service provider to fill that role, you know, certainly I think you'd want to do an RFP process with them, maybe to serve as a statewide provider and be the authorized statewide provider so that you're able to hold them to account.
So, yeah, Chairman Watson, yes, it is doable, but without some oversight.
Well, the analogy, if you don't mind, the analogy I would use is that if you look at the way a person would get pre-authorization for medical care. So let's say a judge rules that a person is eligible for indigency of the electronic monitoring device. That doesn't mean that they will receive it. So they're authorized to receive it. It would then be up to the vendor to determine part of the person's eligibility, just like an insurance company would verify that a person actually has coverage for the physician in the healthcare system. And if the individual then could not produce the evidence that this definition would provide, then they would not be eligible for the electronic monitoring fund under the indigency statute. They would just have to pay for it themselves like other people do. Now it's hard to explain that, I guess, here remotely, but I think that because of the court docket, the judiciary feels like that they don't have the time or the resources to get this information, then what's the next level to get the information? And it's from the vendor who's getting actually paid for the product. Does that make any sense at all to anybody?
Yes.
Yeah, that
That's
makes
me.
sense.
I think it makes sense, but to me, there's some areas of concern that it would raise, just privacy issues and that sort of stuff. I mean, sharing your personal, financial information with these vendors. And again, not to speak ill of the group as a whole, but I'm working on a situation right now with a constituent it's been extended. So, you have the question of who's monitoring the monitors. And I do think that is a legitimate issue.
I would be fearful, Bo, because we have people come and complain to us all the time about what's going on with the particular provider that they selected on their own. And I have no ability to do anything really to help them. And so let's say they kept saying, well, you need this other form and you need this other form. And then what happens is people just start driving without them. And certainly we don't want that to happen, because I think it is a great idea to have these monitors on cars. It protects and saves a lot of people's lives. We don't want people to just give up.
And that's what
What?
the. Go ahead, Jeremy.
Okay, fair enough. What percentage of the General Sessions Court budget is allocated to providing the monitoring device?
Our General Sessions Court.
Yeah.
Across the state. I don't know the answer to that.
I mean,
I don't think any. I would say zero.
Right. So would you, since they're so important, would you be willing to, should we require local governments to make a contribution to this instead of the state funding it all themselves? We do
I
that
don't
with
know
the
the
other
answer
devices.
to that question, Senator, but I do know that it's been, the law seems to add more and more cases of times when we need the electronic monitors that we're supposed to apply them. In fact, as late as recently, the change in the law pretrial requiring them. And so it would seem that we do have to find a source of money for these, because it's more and more, it's being required in more cases. So that leads me to the conclusion that the public policy is to have them.
Well, I guess the point I'm making, it's easy to advocate for these things when you're not having to pay for them. But if you're having to pay for them, then perhaps the definition of who's eligible and the utilization would be a little bit more strict. I think we need to tighten the language of eligibility up. I don't think that the request that's in this definition is unreasonable to the court. And I think the court has the resources to find the answers to these questions. So I would be one that would be in favor of tightening up the definition statutorily so that we decrease the utilization unnecessarily. I'll yield.
Right. Could I say, Senator, it would help also if we tighten the circumstances of when we are using the interlock fund. For example, what types of cases in the one jurisdiction they were using, I think it was Murray County, they were using the interlock fund, $53,000. Surely they don't have that many people that had DUIs. Are the judges requiring them in non-DUI cases and somehow applying under this fund? So
they'd be outside the statute.
I know, but
Yeah.
they have to be doing that or they couldn't get to the 53,000. So could we limit that of, for ignition interlock purposes, it should only be used in cases of DUIs and the additional ones that were added in the recent change of the statute?
Well, this is John Gleason. I think there's two potential problems with that. One, Treasury is seeing all of these invoices already and making a determination that they're allowable expenses under the fund. So I'm not sure that there would be any that wouldn't be approved because you would deny the invoice, right?
Right, so it's the Erica with TCRS. So yeah, we are looking at the court order judgment to validate it, saying what it's for. Now, what the original charge was, we don't go back and research that. We're just going with whatever the court is.
So that's what I was saying is, should they put the type of the charge?
The second problem is what we've talked about in the past with the judges are gonna do whatever they're gonna do. So we could change the law, or we can make the law more clear that these are the only types of offenses required, but that is what it already says. And if they're violating it, then they're just gonna keep violating it. I don't know that changing the statute fixes the judge's behavior. I think we saw that with the Public Safety Act.
Right, I would just add to the Maury count, like, them as an example. I don't know if it's an issue that they're using it, non-discriminately and there's, or if they're just assuming everyone's indigent and not really vetting that. And, we don't know what they're actually doing.
There aren't many counties that have more DUIs than them, weirdly.
Yeah.
Either they're way above in your bigger areas or they're below them. So they do have a high amount of DUIs in that county.
Well, they were
I thought they were
44.
44 out of town, out of what kind?
Maybe I'm looking at something different, but I'm looking at just these raw numbers in 2021 and
The last meeting, they said they were 44.
Yeah, they're 44th. If you look at, if you take an average and look at the fiscal year of 2022, which ended in July, and you compare that with their expenses under the fund from fiscal year 2022, they're the second highest spender from the fund, but they rank 44th in the number of DUIs.
I may be looking at DUI charges. I may not.
I'm just throwing out ideas here. Another idea is, we come up with a formula based on per capita population, and everything. And if the county goes above that, the judge goes above that, the county's responsible for every dollar above.
Yes.
This is Michelle with ASU, Chairman Watson, back to your point of, if the county has some buy-in or just some kind of, get in the game. So what we had sent, what we had told out of our general session staff repository are all of the fees and fines associated with DUI offenses. Now, several of those, this would be a question for the Department of Revenue and FNA. But, it's possible that you look at the current fines, fees, costs that are there and just see where that's dispersed within the county. Because it's possible that within that list, you could divert or change where that money goes and then have an internal funding source via the costs and fines, fees that are already on the book. Just changing where they go. But again, we talked to Revenue and FNA a lot about that, and we had to last year with the change for restitution. So it may be the same type of conversation that needs to be had on those that are currently there.
Don't we already have a problem though with people not paying those fine fees? So even if we change
Yeah.
what portion from what type of fee, I think we're still in the same problem, having a fee-based budget that we can't rely on.
Yeah, I mean, you're always gonna have that issue, but you could also just look at what's currently there. If you're, especially looking at the funding portion of it.
So
This is Senator Watson. Again, I think on the utilization side, I think in looking at this and trying to control for utilization, one, we tighten up the definition of who's eligible. But I think that both the offender as well as local government have to have some financial stake in it. Otherwise, there's no deterrent to overutilization by the judges or, of course, by the offenders. If they're not putting anything in, even if it's a minimal amount, I think we have to give some financial responsibility to both those parties to help control for overutilization either way.
And the current statute has that for non-interlock devices. So the counties are currently required to match dollar for dollar with the state if it's anything other than interlock.
Right.
That's right.
Interlock is the one that's fully funded by the state, and I think there was opposition previously to making those match, and that's why it was treated differently.
Well, I'm sure that the county governments will oppose it as well.
I don't think it was the counties that were opposed, but
It doesn't have to be a one-to-one match like we do with the non-interlocks, but I think that if someone has no financial stake, then the overutilization is a byproduct of that. And when you give people a financial stake, all of a sudden utilization becomes a much more important part of the discussion. So you tighten it up by tightening up the definition of who's eligible, and then you give more financial responsibility both to the offender and to the county. That's one approach that could be discussed.
Could I just mention something I just noticed from, since we were using Maury County as an example of maybe overutilization of the fund, and looking at the convictions of only 58 convictions, maybe in 2021, but there's 316 DUI arrests. So
Looking at
I'm sorry.
that, yeah, that's the data I was looking at, is they have a lot more arrests.
Yeah, and so if there's pretrial application of any of these monitoring devices, you would see their use of that fund.
But it would come out of a different part of our fund. They only use 2740 of the pretrial, but 53,000 in the year.
Which may go up with that new law, so to keep that in mind, because that just started July 1st. And if y'all want to talk fees and stuff, I know Chairman Bell stepped out for a second, but y'all had asked us, the Department of Safety, sorry, this is Elizabeth Stroker, how many people we have that are revoked for failure to pay court calls, fines and fees for DUIs, and it's in your packet here. It's just a quick little blurb. But for DUI 1, we have over 115,000 drivers who are revoked, who have satisfied their DUI requirements, but they still owe fines and fees to the court. So I think that's a result of them having to pay it in full. Then you can see as we go down, luckily there's only one DUI 8 offender that hasn't paid, but he's probably got some other, he or she, some other shit we can deal with there. And I don't know how that correlates to what Michelle and them pulled, but you can see from their data that there's a ton that still are owing court costs and fines to them. And it may be because
In Hamilton County and Sessions Court.
Yeah.
From the years 13 through 22, $5,558,680 DUIs alone.
outstanding.
And criminal, $3,444,622.
Oh, it's less for criminal.
Because they handle a lot of money. Yeah.
Smaller.
I'm sorry, what were those numbers for?
Those were the numbers Senator owed from, they had us check from 2013 to 2022. Those are court costs owed on DUIs in Hamilton County.
5 million alone?
$5,558,680 is what, and I've got the case numbers as well, so I assume the amount's correct that they gave me. And then from criminal court, $3,444,622.
We're talking like 9 million in just Hamilton County.
On DUIs.
Just on just.
To pivot just a little bit, it's not exactly tied to the conversation around indigents, but our office, has been talking about this, and it seems like there's a lot of revenue issues with the fee-based structure of the program. And so we wanted to propose to the task force, setting up basically a recurring appropriation to the Department of Safety to do all things interlock. And maybe structuring a lot of the parameters of the program through, the Department of Safety managing the interlock component of the current EMIF. Then you've got the non-interlock side, which is a question, and we think it might be worth exploring eliminating the non-interlock indigency fund component as it currently exists and reestablishing a grant program of sorts that the local governments can essentially receive some sort of state funding and set up their own structure parameters to support these types of community supervision activities. And I guess the goal would be just to kind of, like we talked about in the past, bifurcate the fund where they're not, dependent on each other, and get away from this financial, the revenue issue where every year there's inconsistent application. There's a lot that can go into this, but we wanted to propose to the task force of maybe thinking about a restructure at some point.
Hey, Grant, was that Grant that was talking?
Yes, sir.
Yeah, that was just Senator Watson. So are you saying that you're proposing that we eliminate the fees that fund the interlock and simply do a general fund appropriation to safety?
I think the fees in our thought process would just go to the general fund, the existing DUI court fees, and then we would allocate specific funding to the Department of Safety for the interlock side, and then to somewhere else within the executive branch to do a grant program to local governments to support the non-interlock side.
You're saying keep the fees as they are, but tighten up indigency definitions, and then not have it just solely come from the fees, but the fees still be an aspect of it.
So the fee, this is John Gleason. It's my understanding, Grant, correct me if I'm wrong, that the fees, you're not going to touch the fees. Instead, the only thing we're touching is where the fees go. So instead of the fee, a portion of the fee going to the EMIF, all of it's going to go to the general fund. So that money is still recognized. And then separate from that, you're going to appropriate from the general fund an amount that goes to safety to run a ignition interlock indigency program. Is that correct?
Correct.
And then on the other side, you would help counties through a grant program, whether that's through FNA or some other department. You would help counties set up like what Hamilton County has, where they're running their own program and working with vendors. They would apply for grants to help set up a similar type program.
Correct. And a lot of the conversation that we've spent the last hour on indigence can still apply through the structure of how those funds operate. It just would be less of a fee-based claims process to the Department of Treasury, and kind of the more use the data to determine an appropriation amount depending on what we anticipate is needed.
From the revenue side, this is Senator Watts. From the revenue side, I don't have that's kind of what we're doing now, really. It's just not formally. But I do think we've got to tighten up the utilization side of the equation as well by tightening up on the definition as to who is eligible for the EMIF funding. And I think the offenders have to contribute to the cost, whether it's 50 cents or whatever it is. They have to contribute something. I think the data is pretty clear that people who have to provide some of the cost will have a better outcome. I think the data is clear on that.
Judge, did you say, if I remember right, or Alex said last week or last time we met, like kind of like $5 a day, or not $5 a day, but at least $5 a month was kind of a minimum.
Yeah, most of us do at least $10 a month.
Okay.
I don't want to get in the weeds because I know we're focused on in this and interlock, but also I am concerned because on multiple offender DUIs, we do use the fund pre-trial to keep people from drinking while they're on bond. And, you know, I would hate to like, obviously, and it also goes to domestic violence cases as well for the GPS monitors. So I'd hate to like totally do away because it looks like there was 498,443 that was approved to be spent out of the non-interlock in the past year. So I just was wanting to make sure that's not sort of forgotten, that we do have the domestic offenders and the like out there.
I use the word eliminate, but I probably should more said repurpose.
Repurpose.
Establish a new system where the local governments run their own sort of fund essentially.
And
with
right now
state
it's half, it's 50% that we had to buy in.
Well, you know, if it's worthy of protecting the funding, it's worthy of the legislature funding it.
Yes, sir.
You know, I'm much more leaning toward this should be dedicated to DUI only. And if we believe the domestic violence part should be funded, we should fund that from a different source. Not that it shouldn't be funded, we should fund it from another source, even if it's general fund money.
Because right now, not much of it is going. I thought there was no leftover that could even be used because the interlock side was just.
I think she said there was almost $500,000.
Well, you paid our invoices, it looks like, for
For
$500,000.
Hamilton County for the non-interlock? Yes. Yeah, so with the camp for non-interlock,
Oh, right, they pay into it.
right, the
Also,
counties
got it,
pay
yeah.
50%. We
Yeah.
match the 50%. When they hit that limit, we stop paying. So we do a 50% match each county on non-interlock devices, and once they've used up their fund balance, we stop paying all non-interlock devices as it's currently handled. So we track how much we're paying out to each county. Yeah, also I did some rough numbers. I couldn't get exact numbers, but I'll say these are not the very last slide in the packet, but the last 2 pages. We've got the total amounts that are paid per county of how many, offenders require some type of payment versus no payment. You can see, Hamilton County is not by sheer volume. They have the highest number of, offenders they require at some payment. We've got several counties that of all their offenders require no payments at all. Just like a rough average, we didn't have full data, so I didn't want to provide it, but of all the offenders that are paying something, the average is about $33 per month per offender that the courts are asking to pay. Kind of a buy-in.
It depends on the county of,
Yep.
see a lot where it's 0%.
Well, again, this is Senator Watson. I mean, so I'm making the assumption that all these people have a car, so they've got a car, they all, I'm making the assumption here, they all have insurance. We all know many of them don't, but they're paying for insurance. They're paying for gas. I mean, the idea that these people are destitute, it just doesn't, I just don't think that data supports that they can't pay something for this. And then I guess I'm kind of scratching my head. I didn't know we were using this fund for anything other than the DUIs. So we're using it for other things?
The non-interlock part, Senator Watson, the non-interlock part is used for electronic alcohol monitoring. And on DUIs or whatever we require it on actually, and for the domestic. That was changed to add the domestic. I don't know what recent years. I don't know what year, but it was recently, Senator Watson, that was added.
Okay, all right.
Maybe within the last 5 years.
I believe it's 2019.
2019.
Yeah, 2019. This is Roy West, Department of Treasury. It's David Conrad. I think the non-interlock devices sometimes are used for more general drug offenses as part of the rehabilitation of the person. And I mean, the counties, the way when that changed, we explained it to our membership that one, the fund was going, it was being completely depleted. So if you want this program, we're going to have to chip in. And two, the idea on the non-interlock was that these are actually things that by using the ankle bracelets, using these monitoring devices, it was diverting people out of incarceration. So the county was saving money. So the counties need to be stepping up to the plate and contributing on those. To some extent on interlock, using an interlock device is not reducing your incarceration. I mean, they're still having to serve those mandatory minimum times. I agree with Senator Watson. I think the folks that are using these, I mean, one thing we haven't mentioned, and I don't want to be callous about the effect of addiction, but these people were obviously spending a lot of money on alcohol prior to this, that you would think they could contribute 50 cents or $1 a day towards monitoring or something. I don't know how, because there's a separation between the appropriators at the county level and the spenders, where a lot of the judges are making the decisions on, are we going to require an offender to pay anything? How many people are we going to declare indigent? Are we going to go through a process of actually making improved indigency? That's all within the purview of the judge. And the county commissioner, the county mayor didn't really have any input over that. So it may create more pressure fiscally at the local level if that county is saying, hey, we had to levy some taxes to pay $50,000 to help cover the cost of this in our county. But if there's no other oversight or no other requirement of documentation or anything like that, the judges that aren't really paying attention to it right now. Yeah, and I'm not including Hamilton County in that. But
96% of us, Senator Watson.
yeah, so they're requiring the offender to pay something in 96% of cases. Murray County, not to pick on them that we talked about earlier, is only requiring someone to pay in 7% of the cases. And
We
that
only have
has
hired
to,
to go as late, and it looks like they've only got one person in the program, so.
so I think if we can have some tools to help us hold the judge's feet to the fire a little bit, so that more are behaving like Hamilton County and less like some of these that aren't really doing anything to keep costs down.
Senator Watson, one of the things that used to happen, people used to just wait the year and then they didn't need the interlock. But the law changed to require that even if they waited the year, they still have to have the interlock. We would have a lot of people that would say they don't have vehicles. A lot of people convince other people to, not a lot, but some convince other people to let them put interlocks on their car, say their girlfriends or their boyfriends and the like. So I don't know that they all own their cars. At least in my experience, seeing people in court.
You're right on that. We deal with a lot of people who, they either decided to get rid of their car because of their DUI, and then realize that they have to do this interlock requirement. So they'll either buy a really cheap one, and just park it and only go to their monthly calibrations and not actually drive it, or they'll put it on a family member or friend's car. That does happen.
As we speak of finances, I know that this is more national in scope. We know from research that generally DUI offenders are employed. Whether or not they're employed at the time of their DUI is another case. But we do know generally they are employed, they're higher income than other offenders. And from our own exit surveys that we asked people who've been on the Scram alcohol monitoring bracelet to fill out, they self-report that they're spending a minimum of $13 a day on alcohol. So, $10 a day is a savings, but this is Tennessee, and Tennessee's not the nation.
This is Senator Watson, and I'm sorry, I'm the most ignorant person on this because I don't serve on judiciary. I haven't been engaged in the conversation as much as Chairman Bell and perhaps others are. So I apologize that probably many of my either questions or comments are somewhat ignorant. But again, I think the state is certainly committed to the interlock system. The others, that was the original statute, was to do the interlock system, and that the state would fund the interlock system. And then, of course, as everyone knows, we've ventured off into other aspects of it. I get all of the different reasons of why people shouldn't pay for something. But if you don't make, somehow judges have some financial accountability, and you don't make offenders have some kind of financial accountability, there is no constraint on utilization. And this fund has been challenged with overutilization that outstrips the revenue source. And while Grant's proposal to do a recurring recurring revenue to safety is smoother, and I like that. It doesn't address the utilization side, and all we'll be doing is spending, giving safety more money every year because there's no constraint on utilization. So this group has to come up with some way to constrain the overutilization of the device to help control the cost.
And I think one of the hurdles that we talked about in the previous meeting, and sorry, this is Representative Hazelwood, the fact that our Hamilton County judge, an exception, we really don't have a mechanism that, in the discussion previously at least, there was no mechanism to put those kinds of restraints on utilization in the courts. There was no methodology that we came up with, at least in that discussion, that would allow us to force, if you will, judges to require payment, or to only, like in Murray County, when everybody is considered indigent, evidently based on the numbers, then, that is a huge area of opportunity, I guess, for constraining this, that so far I haven't seen a lever that we can push to make that happen.
So if we consider as a part of our recommendations, tightening the definition in a way that would decrease utilization, and then paired with requiring all users to pay in some form, even if it's $1 a day, is that moving the ball down the field a little bit?
Yeah, I think if you tighten up the definition and you require some minimum amount of payment, then yeah, that helps to start to put some restraint on utilization.
What we have to be careful about, though, we set a minimum, but that doesn't then become the standard.
Right.
Yeah, and we don't want to, always easier to go back than it is to go forward. So if we set this minimum, let's don't worry about setting it maybe a little high. And then, we come back in a couple of years and we can come back down on it to start with. Let's first let's err on setting it too high.
Yeah, something like no less than, I'm just making up a number here, but no less than $5. I don't know.
So, go ahead,
David
sorry.
Conner, I was just going to suggest, what if we set a minimum that all persons on this shall be required to contribute X amount a month unless they can present documentation to prove that they can't. So it's actually the onus on the defendant. If they really don't have the income to pay for this, we don't want to force them to scrounge around and take money out of their kids' mouths. But if they're saying, oh, I'm just going to lie to the judge in order to get away from.
So instead of determining indigency, you set what somebody has to pay, and then.
Unless they can prove their indigency.
Wouldn't that still require the judges to do a lot of the
Well, then that would make
Grading homework.
that defendant's gonna have to present some
Take
documentation.
it all off of the judge pretty much unless the person wants to be declared. It would basically put it on them for having to show that they are indigent.
Who are you talking about turning that additional paperwork into if they, in lieu of their so many dollars a day, and then in theory, would they be turning that paperwork into a vet?
Guess we can debate whether that's more effective to have them do that to the courts or have them do
I
it.
was gonna say to the service provider, but sorry to the.
All right, this is Representative Hazelwood again, and a very ignorant question, but how do we determine the maximum now? I mean, what is the maximum cost for this?
Well, the maximum's the 125, right?
Yeah.
It's statutory.
It's captain statute.
Right.
All right, so if I guess I'm missing something here. If we say that the maximum you have to pay is, 50 or whatever, unless you do all this, it seems to me that we would be driving the behavior the other way, but I'm probably missing something, so.
You have to adjust it.
Yeah, Chairman,
It's capped. So if you only do must pay 50, that's not going to cover the full cost. Then everyone would be.
this is John Gleason. Chairman Hazelwood, I think you're correct. I think we need to say you pay for it if you can, unless you're indigent. And then once you're indigent, we say you have to pay X amount a day, even though you're indigent, unless you can prove that you can't even make that. Because I think unless we do that, then to Chair Lady Hazelwood's
Yeah.
point, people are just gonna pay that 50 and not the 200, so.
Right, my thought was not about requiring the defendant to pay 100% of the cost, but requiring that defendant, you're gonna have to pay
Requiring
something.
an indigent defendant to pay.
That's something unless they can prove they truly can't afford even $1 a day.
And I think Treasury said the average of people that do pay something was 33.
That's current, per month, currently. And that's everybody across the board.
And $1 a day would be
The
30,
people that do pay.
roughly 30.
So we could set it at 30 for indigent.
Or whatever verbiage the judge would recommend with $30 a month or $1 a day, whatever it would be the same, whatever would be easiest to understand.
Right, and I just have one other question, and I'm sorry, but even if we put that in statute, like now we have this indigency in statute, what enforcement mechanism do we have to make sure that judges follow these rules?
Good question.
I wish I knew. I wish I knew.
This is John Gleason again. We had discussed previously requiring reports to Treasury or the General Assembly or having the comptroller audit this program. So we could potentially add that sort of mechanic. There's nothing currently in statute, but we could add a reporting mechanism and or an audit mechanism to make sure that the new rules are actually being followed.
The comptroller audit the outliers, maybe they perceive that there's.
Yeah, that's what we discussed. I don't know, the top. How many session judges are there in state Tennessee? 300 and.
No, I can't.
I think it's only.
Yeah, it's between 1 and 2, but I can't remember the exact number.
The top 5% or something.
You're saying submit a report, have them all submit something and then the comptroller audits them. Yeah.
This is Senator Watson. Just the chain of command for the judiciary. Do the general sessions courts, do they report up to the administrative office of the courts?
This is Michelle, the AOC. They do not, Chairman Watson.
So they're independent they're just completely local.
Yes, because we don't have a unified court system, so we would have no authority over the general sessions courts.
So
They all just got reelected, so.
Right.
That's
So
kind of
the state and again, I apologize because I'm not on judicial. I don't pay that as obviously as close attention to this as I should. So the state is paying for something for which it has no authority to enforce its rules.
Other than by statute, or, you know, that we can do it, right?
Apparently not, because we currently have statutory language that
Well-
does not appear to being followed.
Senator Watson, the statutory language is so, it only asks 2 questions, is what I'm trying to say. If you do ask additional questions, maybe the judges would ask it, you know, and like include what the family income is. But as the statute's currently written, the session judges could be asking that, you know,
Yeah.
could be following the statute. It's
Okay.
just, it's not very clear what, there's nothing else they should ask.
So Chairman Watson, so this is Michelle. So in the code, it just basically it's, are they able to pay? If you narrow that and put more specific questions, then I think after you put that in the code, let that go into effect, let us educate the judges on what they're supposed to do at their conferences, and then come back and see what the numbers are in the next year or 2. You may see a significant change just by adding more specifics into the code.
Right.
Okay, and again, thank you, Michelle, that's helpful. I guess we were talking about this and there was discussion and people chuckled a bit and said, well, if we can get them to do it. My impression or my thought around the judiciary is that if we put it in statute and we say they have to pay a minimum amount, then all judges across the state at the general sessions level who are responsible for applying this law will then charge everyone the minimum amount. There will be no outliers because that's statutorily they have to charge the people the minimum amount.
Right. And,
That's the hope.
well,
But-
they won't
but
be
it-
reimbursed if they
there
don't.
is-
Their county won't be reimbursed.
That's right. That's right.
So they will have to follow that.
Yeah, I mean, that's a great point, Judge. That form comes into the Treasury Department and they say that they've not charged them that minimum, then they kick it back to them. This isn't gonna be paid.
Is that authority in the code for them to deny it?
It would have to be
If not, it can be-
That's what, I don't think there's anything in there for them to like outright deny. So that could be a good option, that whoever is controlling this fund has the authority to deny reimbursement if statutory requirements are not met.
Yeah, I mean, we do have some language that says if there's any markings on the document that look invalid or there's certain criteria that's not met, then we can deny. And
This would be criteria.
yeah,
Yeah,
so.
good
And they
idea.
do, and you do kick them back.
Senator Watson, that would be a good way to put some controls in.
Right, what
Get
you're
Treasury
getting-
give Treasury the authority to deny.
Well, you're getting to kind of where I was trying to get, which is, since we appear to have the state has limited jurisdiction over the local general sessions court, the only way to put constraint on it is to have the ability to deny payment for claims which don't fit within whatever definition we come up with here. And then make the county government responsible for paying for it. And I believe that if you do that a few times, that the county government will then say to their locally elected judges, hey, man, you're killing us. We're losing, we're gonna have to raise taxes because you guys are overutilizing the indigency definition in the fund. So that's kind of where I'm trying to get to with this discussion.
The reimbursements go to the vendor though. They
To the
don't go to the
vendors.
county. So that would be problematic because the vendors are not the ones doing indigency. And so then the vendors wouldn't receive the money for something.
They would just make the defendants pay at that point.
So that you'd have to change that process because right now the reimbursement's going to the vendors, not the locals.
Yeah.
And so then they would be out of the clear as well because they're not paying.
So how kind of problems we create by making the money go to the county, let the county pay the vendor?
It'd be a county question.
I think that's for the non-interlock side, what we were envisioning. Pull everything interlock under safety, and then all non-interlock in some form goes out to the county governments
But that doesn't fix the interlock right now reimburses the vendors. It
Right.
does not reimburse the locals. So you'd have to, if you're gonna go that route of withholding money for something the judges may do incorrectly, that's not gonna work.
Right.
Because
As
they're
you
not
said,
receiving the money. You'd have to change the current process. Because right now it's just the vendors who are out of luck if something doesn't get paid. They have to do that or they charge the offender.
I would suggest we tighten up the language, that who meets the criterion. We put in a minimal amount and we implement that, and we task someone with auditing those counties that are outside the range, a certain amount of those in a year, and come back and see what kind of impact it's had on utilization, to see if judges are actually implementing the law as we have written it. I think Michelle pointed out, give them time to educate on that. So you give it a year. And we also consider adopting the grants proposal that create a recurring amount that goes to safety for the interlock fund, and the state stays committed to the interlock fund, and we allow the other to be through a grant program, which is kind of what we're doing indirectly now anyway. That would be my suggestion at this stage.
I also have a note that we wanted to get rid of the requirement that DUIs be paid in full. We discussed that in previous meetings, and I know y'all wanted to potentially adopt that. So I wanted to make sure other stuff we discussed is also is that something everyone still wants to look into?
Yes.
I know that would help us in the court, so that's an easy.
It would
fix.
help get more licensed drivers, I guess. What, this is just saying, what was the underlying policy behind requiring interlocks if they waited a year? Because I think that's increased the utilization of the fund as well.
So that was changed back in 16, due to the fact that, and I'm gonna put this the best way I possibly can. It was discretionary on the judges of if somebody needed interlock or not, and the judges were not requiring people to get interlock. And so you were seeing higher reoffender rates, or, or people who would just sit it out if they chose, to sit it out and then maybe would reoffend. And so the policy decision there was made by the legislature that we don't want people to be able to sit out the 1 year. We want them to show that they can drive for a year and not have any violations or problems, so we can trust them to drive again, as opposed to just being able to sit it out and then come back, get a full license, and then.
And they haven't changed their behavior in that year. They've been
Right.
drinking, and so when they get that license back, they're still drinking. So
Or they were still driving because
Yeah.
we know most of them
That's what she'll
still driving.
But I think it does increase the utilization
Yeah,
of the fund that we haven't necessarily.
And the fact that it took a couple years for all the courts to fully understand that law. So for a while, you didn't see a change. And then I think it was probably 18, 19 when the courts finally caught on that, hey, we can't just let people sit this out anymore. So we had a mass influx of people who were on the fund because they weren't.
There's
Right,
probably
previously.
not a person in the legislature who didn't hear from constituents and said,
Exactly.
why they're making me do this? It's
The
been
judge
easier."
told me
So
I can just.
That's
sit it.
right. So
Yeah.
I'm not hearing from them anymore, but I probably heard from a
It's
half a
definitely,
dozen.
it's much better now.
That's right.
Yeah. But for that 17, 18 year period, we were getting calls
Yeah.
daily from people who.
So this is John Gleason. We keep circling back to tightening up the definition of indigents. So can we walk through Grant's proposed definition?
We have no authorship over that, so.
Right,
We want this-
but it's a starting point. So can we walk through that definition and see if there's anything in there that task force members do not want in there? Or is there anything in there that task force members do want in there? For example, I know that when we talked about it, and we talked about point 2 resides in public housing, that we had said that we would want a definition for that. So if we could walk through that line by line and make sure there's nothing we want to take out, nothing we want to add, So we can start firming up what these recommendations are actually going to be.
And to recap on, we're looking at the definition of indigency, but as we talked about, an indigent person who still is granted this, going to be required to pay something unless they can.
Potentially $30 a month. Yeah.
That's right.
Earns less than 150% of the federal poverty guideline. Can you read the way it says now, Michelle, with that? In the,
I have the code section if you want me to read it,
you can
Michelle.
read that.
So Tennessee Code annotated 55-10-419D currently says a person is indigent and financially unable to pay for a functioning ignition interlock device if the person is receiving an annual income after taxes of 185% or less of the poverty guidelines updated periodically in the Federal Register by the United States Department of Health and Human Services under the authority of 42 USC section 99022.
So we may need to add the after taxes.
And I think you said you'd prefer to say household income rather than.
I think it would help catch, I don't know if we can do that, but
Yeah, I don't know,
because they're not,
because if you're gonna use the percent, then you'd want to do that individual and then ask if there's additional income in the household. But
maybe you could put that as that you could take into account additional income and.
We may want to leave that in because what we had also talked about previously was having this definition, but then adding a point that says other evidence to the contrary can be introduced. So that could be that additional household income.
I will add, one of our other attorneys looked at this after I distributed it and made a comment that there was a lot of kind of more drafting related
Right.
check questions and changes that would need to be revisited later. You know, for instance, like putting the code references for foods
Right.
instead of just stating food stamps.
But can you really take into account child support because it doesn't really go into your income? I mean, in the truest sense of the word, it's not income. Alimony could be, but your child support can't.
I'm gonna ask a dumb question, but a practical question. As we're developing, because I know next meeting, we're gonna work on developing the report of the recommendations. Does someone want to bring what all we're going to want to include in this recommendation? Or are y'all just wanting to, say, hey, we recommend redoing this definition or, restructuring, tightening up this definition? Or do y'all want to actually include what you want specifically to be in the definition, or just broad, it needs to be redefined?
I don't think it needs to be a draft legislation, but I think it needs to be specific enough.
Yeah.
That it's a true recommendation from the committee. So again, the draft of the recommendation will be done by. Probably done all.
Well, that's not why I'm asking this question, because indigency is not our subject matter.
Yeah.
Specifically, the rest of it, I think I can draft out and put in a recommendation, and that can at least do y'all want the draft of the recommendation for the next meeting, or do y'all want to come up with it and create it at the next meeting, and then let everyone sit on it and approve it? I'm just trying to prepare for the next meeting.
I would suggest, you've been listening to all this, I would suggest you go ahead and come up with a starting point, as we talked about on what the trim brought. So go ahead and come up with a starting point and draft, and let's go from there.
Okay.
That's up, yes.
Yeah, and this is Michelle at the AOC. I think that between the and the administration, safety, the judges, we can look at maybe what would be realistic for the judges to pull, and that could be, you know, this is, you have it or you don't. And I think we need that, to figure that out before the next meeting, come back maybe with a little more solid.
That's what I
This would be a
was-
1, 2, 3.
I was gonna say, because I figured we were gonna have to be the ones who draft this report as being tasked as the chair of this lovely esteemed task force. If y'all could give us, because indigency is not what we are comfortable with or subject matter experts in, so if y'all can give us specifically what you want me to include, so I can include that before the next meeting, or y'all can let me know here, I can write it down. I just don't want to pretend to know anything about indigency on the court level.
I think the judges and us, the administration could kind of see what is doable, because you don't want to put something in there that's right, but you can't find it because they don't have the information. So we can just figure out exactly what could be provided, that the judge could look at and say, yes, this is something official from whether it's HHS or whoever. And then I think that's something we can narrow this down to the next, and specifically reference whatever statutory.
Where we
codes
would
that
put
could
it in the
yeah.
statute. This is Judge Statham again. I do believe that if we add letting people be on a payment plan for DUIs, you're gonna increase your number of interlocks as well. So we need to explain that somehow in there. That
Potentially, because our hope is that everyone did it during their revocation period.
Take it
So,
off, but you
right.
might have
or already did their
one of these
interlock.
100,000 people that haven't paid, say, oh, I can be on a payment plan now. I want my interlock and I'm gonna start.
Well, these are, so think, the full payment's not due till after that revocation period. And so hopefully they all did the interlock during their revocation period. So that would already be done whenever they would then come to make that final payment with the.
Right,
court.
on the
So
new ones, but I was talking about on the old ones that you.
Oh,
got.
yeah, the old one.
There's 100
Yep.
something thousand that are
They may have already done the interlock. We just don't know. Some of them could have
are
already
still
done it,
revoked,
but are still revoked because they did the interlock and then didn't have the money to pay the, what's due for the courts. But yes, you're right. It
so
could. increase
it
it.
could increase your numbers.
This is John Gleason. Last time we had talked about, we would see how this meeting goes and see if we need another meeting before that final meeting when we were approving everything. Since the courts need to go back and firm up what is possible for the definition of indigency, do we think we need that other meeting?
Circulate it, you know.
Yeah.
Email.
That's what I was thinking, I could circulate it once I get some information from the courts and the judges on that definition. The rest of it's pretty straightforward on what recommendations y'all want to do. And we can circulate it maybe a week before that last meeting, let everyone look at it, then we could go in, tweak it, spend a couple hours, because we can pull it up on the screen and edit it and stuff while we're in here. I think it's definitely doable.
Okay.
It's just a matter of if y'all want to have more time to discuss anything else that you may want to include in the recommendations. And that's where we can kind of go through, we see what we haven't discussed on here. We went over the DUIs per county for that Michelle and them provided. We went on unsatisfied DUIs, number of people paying. We went through that with the Treasury Department. Did that as well. We've talked about the fund and what to potentially do with it. The last thing we had on here, Grant, was the request for the poverty rates per county and how that plays. It's in your packet where you can see where they fall. If y'all wanted to look through that and discuss that still. Grant, I'll let you
Just
know.
send it out,
It's, yeah, it's in the packet that everybody's got in that
I think-
PDF.
might be more useful. If you have interest, pull it up on your computer and sort based on the information you're looking for. There are these big, long spreadsheets.
This is what it looks like, Kevin, for you to pull it up on that page. It's this.
I mean, all we did was we took the ARC data that gives every county a economic status index, and we put it right next to the county's DUI convictions. And I think the intent was to see if there was a correlation.
It's like you have to, it's like at the very end. So yeah, it makes more sense to pull it up as a spreadsheet, but if you scroll down, yeah.
I think, to be frank, it just seems like this reinforces the theory that this group has had, that there's not a very strong correlation between the county's economic status and the utilization of the EMIF. That it's somewhat more dependent on other factors that judges are accessing, utilizing the fund and things like that. I mean, like Murray County, let's see, it say,
I was gonna look and see what it was.
C has Murray County as a tier 3 county. That's 1 being your Williamson counties, 1, 2, 3, and 4. Montgomery County, you can see that there's quite a bit higher utilization rate in Montgomery than Murray. And obviously there's population considerations there, things like that. I think the intent was to see if that correlation was there, unless someone else sees it. And I don't know that we saw it. It was very strong.
But it might account for some of it, because for example, Hawkins is a 4. And that might account for why they're 26th in DUIs, but 4th in spending. Because they have such a high economically distressed population.
Right.
So it would account for some of it, but
That's fair.
maybe not all of it.
All right. Any additional comments? Unfinished business, anybody online or in person, got any other comments they'd like to share with the group? Again, thank you for your time. I know we went through a lot of stuff today and a lot of work got done. Some tough discussion took place, but I'm glad we had them so we could help see everybody's point of view and stuff, what's transpiring. But
Got the next meeting scheduled for September 13th. That's a good ways, a month out. So, if I can get something from the courts on the indigency definition within the next week or two, I can send that out well in advance for everyone to review, like a draft recommendation report. And then we can spend that whole meeting editing, tweaking, adding, whatever we may want to do. What? Oh, yeah. I'm going through this before. I forget it. So does that seem doable, or do we need to add in another meeting before that one in a month? Is there anything else that we want to dive deep into or discuss or potentially consider?
Can you remind us when our report is due?
The 30th.
September.
So we'd still have 2 weeks even after that 13th meeting. We gave ourselves some extra time in case something were to come up.
all right, anybody from the public have any comment? Any word from the public? We want to open the floor up. In person, online.
Is there anything in the chat? Haven't seen anything.
I haven't seen anything in the chat either. I'll make sure we give everybody an opportunity to comment if need be. All right.
Okay, I want to confirm that everyone is good with just having one more meeting. I'm hearing no news.
Good. So within a week or so, we'll have the definition, a draft, we'll share that around. 2 weeks. Within 2 weeks, we'll have that. We'll share it with the group. That way on September 13th, we'll be ready to move forward with that. Make things happen. I really appreciate everybody's time. Thank you all again, taking time out. I know work doesn't stop for people while we're still here. Emails still come in and phone calls do, and thank you so much for your time. I really appreciate it. Get a motion to adjourn. Motion to adjourn. Good deal. Second. Thank you. All in favor? Aye. Great, thank you.
Like your Dells.
Yeah.